So Chairman Wontumi abusua ene court and sensem koso and ye ba be dropping a ha se ye mananse ye ba be breaking wa ha e de maamo eye Chairman Wontumi no lawyer mo de application koko pie mo court say eye ne eye judgment no omo kwa arrest and eye say Chairman Wontumi ne case na ewo eye high court no omo person omo refer case no ko supreme court na supreme court eye some interpretations bi ene Deputy Attorney General raise objection or they a block yes application Chairman Wontumi ne lawyer say enka yen refer case no and found Supreme Court na Supreme Court and yes interpretation no ene abusua okopie mo e wo court wa enye asem ketwa na Deputy Attorney General oyobi a eba mra na onim ne yi ankasa right now no wama Chairman Wontumi na so ayehye yenko na yenkonkoti ensema ekoso ewo court wo na eba yede aka ato am so na sansa na ebe kon Ghana ha say open computer papa and a laptop papa na we use the Abura Perosi computers and accessories ho and na obenya laptop papa na we use in the location enya ira kwan o Kumasi Buokrum Estates Eli free number ya egu screen ya se eba yede aka beto am so
about court proceedings today because two important issues have taken place. The first being Chairman Wontumi Samurai Boy case. Talk to us about that and then we'll go on to number one.
Right, Kimni, so like you outlined, indeed, Wontumi's lawyers have filed an application at the High Court for the presiding judge in the matter to refer some constitutional matters from their submission of their final submission that they expect the court to rely on to make their judgment on 20th to the Supreme Court before, after that is determined, then the judge can then make a pronouncement regarding the case. Now, among other things, they indicate that, for example, sections 14.1, 59, and 992 of Act 703 as amended by Act 995, on which charges the court based on or anchored on to order Wontumi to open his defense as regards the submission of the law case which they dismissed hasn't been determined by the Supreme Court, and so it sort of raised a lot of questions around those charges. Now, particularly, they mentioned two of the charges which vote against Wontumi, which is the count 4 and then count 6, which has to do with him facilitating illegal mining operations, the Samabwai concession. Now, they indicate that the Supreme Court has not really determined or given a particular ruling on this matter, and it's bothered on that. And so they need to refer these constitutional questions to the Supreme Court, after which, when it's determined, then the make pronouncements or the judgments in Wontumi's case. So essentially, they are asking the court to halt the proceedings and then refer these constitutional questions to the apex courts for interpretation and then final determination before they can continue with the decision by the High Court of Kimini.
I see.
Apart from that.
And what's been prosecution's response to this?
No, the Deputy Attorney General, he responded to it, indicating that, actually on two grounds, citing that the fact that an accused person or a party make some allegations regarding charges does not give the court the mandate, or the court is not obliged to defer or refer the case to the Supreme Court, essentially halting is that they can go ahead with the decision of the court. And then also indicated that the question that they claim constitutional questions for which reason they are asking the Supreme Court to make a determination are not ones that can class the constitutional questions, because they don't there's any weight as such. And so he's asking the High Court judge to dismiss their application and then move forward with their with the judgment, which is based on next week Monday, which is July 20 Kemini. And so it remains to be seen, because the lawyers are hoping to move that motion on Monday when the case is called. And if the ruling goes in their favor, then possibly the courts will adjourn or defer the judgment again, because you realize that the initial date for the judgment was on 5th, and then it was adjourned to 20 after the judge allowed the lawyers for Wontumi to file their final submissions in the case. Now, on 13th, we reported that they were yet to file the written submissions, but by close of the day, they had filed that submission. and then included the constitutional question that they expect
Very
the
well.
courts to make the decision on.
Very well. Do we have word on that plea bargain in the Exim Bank case?
Well, they were given for 14 days to conclude on that matter. And so as far as the Exim Bank case is concerned, both parties, which the prosecution and Wontumi's lawyers, are still negotiating. They've been given the next date to come to court to give an update to the court on where they are as far as the plea negotiations has gotten to. The last time they were in court, they indicated to the presiding judge that it's progressing smoothly, but they still have some fine touches or nuances that they need to complete on, since they still are within the prescribed number of days that they can make the plea negotiations. And so once that has not been elapsed, they still have time to make sure they fine-tune the little details in the negotiation before they can come to the High Court to give them the update.
I see. Let's talk about NAM1, because prosecutors are now trying to determine whether or not at the time he transitioned from Menzbank to Menzgold, he had license to sell. What are we learning?
Interesting development there, Kimini. So NAM1 initially was making oral evidence, and she was giving his evidence orally, but then was directed by the court to file them in a written, file his evidence or testimony in a written format, because it was kind of stretched. Now he completed that today. He was led by his lawyers to finish his evidence in chief, after which the prosecution, led by a principal state attorney, Watkins Adama, cross-examined him. Now, know this, Kemini, although NAM1 is representing Menzgold and then Brugge Marketing Consult, both companies, he is testifying for only himself, which is him as an individual, as a CEO of Menzgold. Now, both Menzgold and then Brugge Marketing Consult will not be a witness to these companies. They're expected to file their own witnesses, although Kemini, NAM1 is the one who is standing for both companies, saying that both companies, he's representing them. Now, when it came to the cross-examination, the principal state attorney sought to establish that he, over a period of time, first changed the company name from Menzbank with a K to Menzbank with a C. And NAM1 answered that it was based on the advice of the Bank of Ghana, highlighting that the central bank was very much interested in this bank because their business was novel, and so the central bank paid critical attention to them. Now, he indicated that after changing the name from Menzbank with a K to Menzbank with a C, they got an agreement with the government in August 2016 for essentially him to sell gold to look infirmities. Now, he indicated that, this is the prosecutor, he indicated that afterwards, that's when NAM1 set up the company, which is Brugge Marketing Consult. Now, he sought to establish that after that agreement with government, NAM1 set up the company Brugge Marketing Consult, in which he has 70% shares, and then 3 people have been cited as directors, he, his wife, and then 1 other person. So they're the sole directors. And then he sought to benefit from this initiative or agreement that he had with government. So that case has been adjourned somewhere next 28 for the cross-examination of Nana Piamens and NAM1 to continue.
We'll leave it here. Thank you so much for talking to us. We can now take a listen to Fred Forson, who's spokesperson for the aggrieved customers of Menzgold.
I'm going through a lot, and I, for instance, as the leader, the convener of this group, I can tell you I am being haunted even by the mere memories of those who are dead. Day in and day out. Sometimes when I wake up, because I remember Nana Kisi, for instance, he died in my presence at 37. And I can tell you, Sister Janet, he had over 600,000 cedis in Menzgold. He drove to my house, she brought her data. She died, she had diabetes, she was blind, and the stuff like that. They are blood. I don't know. I am haunted. Sometimes I hear them asking me, still we are not able to retrieve their money. And I remember at 37, when I went there, Nana Kisi was there. I got to the ward, and I touched him. Then his body was
now governing NDC. This is what they say with respect to the judiciary and tribunals to support the Chief Justice to establish regional tribunals as provided for under Article 142 of the 1992 Constitution, and also pass legislation to reintroduce community and circuit tribunals. And so what we know is that per the court structure, the judiciary, regional tribunals are captured in the 1992 Constitution, Article 126 to be specific, which details the various superior courts in the country, the Supreme Court, the Court of Appeal, the High Court, and then regional tribunals. So that's been catered for in the Constitution. This aspect about passing legislation to reintroduce community and circuit tribunals is what chiefly as well was contained amongst many other things in that bill which was passed yesterday, as well providing a bit more in terms of details for the constitutional provision of regional tribunals in the 1992 Constitution as well. Now, they also say they are to review the Alternative Dispute Resolution Act 2010, Act 7982, establish ADR clinics at the community and district levels, operationalize the Independent Tax Appeals Board, ITAB, and other commitments they were seeking to make. Speed up, right, the determination of cases through automation and the introduction of a judicial shift system under the 24-hour economic policy. With regards to this, we've seen the introduction of afternoon courts by the current Chief Justice, where a number of cases are seeing them hearings are starting in the afternoon, which is, according to some of the lawyers we've been speaking to here, it's provided for a bit of speed as well in terms of the progress in case delivery and all of that you do not have to wait long just to pick a date, amongst other things. Now, they also add that they will fully implement the e-Justice project, right? The e-Justice project, which is to see a lot of digitalization within the court structure and the court system, such that filing of papers and then the documentation, which can be laborious sometimes, and arguments can come about finding dockets and what have you, can be taken care of by this as well. And also introduce virtual hearings for selected cases. It's been piloted to a great extent, this on a number of cases, right? A number of cases which we've seen that has happened. But of critical importance as well, use artificial intelligence and automation to improve justice delivery as well. So these are the recommendations. Establish high courts in the 6 newly created regions where they do not currently exist, and establish courts of appeal in the western, northern, and Volta regions as well. I'm going to take us onto the phone lines right now and speak to Kwame Enyimadu Enchu, who's a ranking, right, on Parliament's Constitutional and Legal Affairs Committee, to pick a bit more from him as to this. Honorable, I appreciate you for joining us this afternoon. Walk us through the decision by your side in vehemently opposing this bill, and which aspects of it you say should not be countenanced at all.
Okay. Good afternoon, sir, and to your listeners and viewers. We have gone through the reading of the bill, the first reading, after which we went to a committee meeting. After the committee meeting, we did the second reading, where we spoke about the principles of the bill. Now, at clause 4 of the bill creates the regional and district tribunals. That is what the bill seeks to create. So an amendment was proposed from our side that even though there is a mention of the regional tribunal in the Constitution, we have far moved away from tribunal system, and the creation by an act would not be the best. So we proposed an amendment, and the amendment was opposed. So
where the amendment was asking for what?
The amendment was asking for deletion of the clause that reads the regional and the district tribunals, the creation of it. So that one was objected by the majority. At the time we did that, I think about 23 people, or not more than 30 of the NDC members, were in Parliament. The leader of the House, Honorable Ayariga, then said that he is calling for us to go into recess. We went to recess, and he marshaled all his people. He called for a 3-line whip, and almost all of them came. So we stayed from 5 p.m. when the House was suspended until about 10 p.m. when they were ready for us. When we went there, we continued. And then we realized that there was nothing we would do that they would listen to us because they had the numbers.
Right. Honorable, I want us to go back to... All right.
And let me land, please.
Right.
And Honorable Ayariga himself said that whatever we did, they were determined to pass the bill yesterday. So we have to wash our hands off from the bill that we call it is. We say that it is not a good bill for Ghana.
I'll come to the additional aspect of why it is not a good bill. But clause 4, you say you were proposing a deletion of regional tribunals and then district tribunals. Listening, that speaks to the heart of the bill which was before you as members of Parliament. Wouldn't a deletion, at least from what I'm understanding, have rendered the entire bill moot, since they were seeking to, amongst many other things, yes, the Constitution takes care of it, but we saw the Courts Act in 2002, which, like I've described, puts regional tribunals to sleep and sort of eliminated the district and community ones. They were seeking to have that brought back. And so help us understand what that deletion would have sought to serve, and if it was not going to negate the purpose of the bill.
Your observation is right. But our reasoning was that so far as the Act is creating, especially the district tribunal, that was unconstitutional. That was the basis of our argument. Now, if it falls, and everything falls, so be it if it is unconstitutional. So that was our argument. There are other things, but we didn't get there. But because we were there, it paved the way. We were out, it paved the way for them to continue with that. For instance, there was a clause that the bill would be done on a day-to-day. A clause that when a matter is before the tribunal, nobody can make an interlocutory appeal. And all those things, we thought these were unconstitutional provisions that they were inserting in Ghanaian. They were using the back door to bring in what we had run away from it. So how can you introduce a bill that says that the bill itself is controversial, that the tribunal system is controversial, and you seek to fine-tune it so that it will not be controversial? It is already controversial and outmoded at best.
Controversial because of the history during the military days, you'll agree, it has been...
Controversial because, not only because of the history, but again, the current also. You are introducing 3 judges. One of them is the chair, who is a trained lawyer. The other 2 are ordinary people. Even the ordinary people, when we say that we should graduate it to a level, somebody who had gone to a tertiary institution who would appreciate what is before them. At least then the person could be trained. They said no, ordinary means ordinary. And then the law also, the bill also says that the two, when the decision must be made by majority. So it means that impliedly the two can decide against the chair of the tribunal. So you will have people, ordinary people, using their emotions, give judgments, and then decide on the fate of ordinary Ghanaians.
Right. There's an argument that's been made that, look, this is positive to a certain extent. It expedites hearings, particularly on matters like Galamsey, which has bedeviled this country. It will lead to a fast track of some of these specialized cases. It will also introduce experts.
Pick it one after. Let me answer that, and then you can continue.
Right. So now, on the subject matter of Galamsey, for instance, how do you respond?
Right. The Chief Justice. So if you tell me that you are creating a tribunal because there is, you can create a court and say this is a mining court or the Galamsey court. Nobody would have a problem. The other thing that we raise is that the judicial system, the judicial committee that we have, they would want to create the tribunal system or the tribunal committee that will run in parallel with that. Now, if you tell me that they want to expedite cases, it is wrong. You look on concern for Galamsey to go on in this country, and then you say that this is the bill that will solve the problem. No. Rather, the three judges, they are human beings. When you put three judges there, when one of them is not well and the person cannot come to court, then their case may not proceed. So that would rather lead to more delay. We practiced and we knew the problems we had.
What about the argument as to allowing experts be on the panel as well, which can help the chair of the tribunal arrive at a better decision? Some of the argument has been made that if you go to some of the traditional courts, there's a lack of expertise sometimes with regards to the judges, and it doesn't allow for justice to be served. This will allow experts be a part of the panel to deal with specific matters as and when they do come up.
The NDC government must as well tell us that they are doing away with all the judiciary and they are forming ordinary people to be judges in Ghana. If they don't have the trust in the judiciary, then they must tell us and sack everybody. Then we know that they came to power and said they will sack people and that they are continuing to sack people, judiciary included.
Right.
That is what they have to tell us. Because what they are doing is wrong, probably wrong.
Right.
How can you bring a bill? The memorandum of the bill itself says that the bill is controversial.
Honorable, two quick questions from me. The first is whether or not at the committee level, the Constitutional and Legal Affairs Committee, consensus was reached as to how to proceed with the bill before it made its way to plenary.
We mean a committee level?
Yes.
What is happening to Ghana? I cannot blame any NDC MP there. What is happening to Ghana? I blame Ghanaians. They have the absolute majority, and it's the same ratio we use at the committee level. The others, when they say that consensus was reached, I don't know what they mean by consensus, because the proposals we had made, they said no. And even the suggestion that we should get a highly educated person to be the ordinary person. When the report came, they said, they changed it and said ordinary means ordinary. And I raised it that this is not what we agreed on. So, and then when we came to the house and were doing the second reading, all these issues were raised. And they said that what the NDC Abana had become Ethiopia. So they wouldn't listen to anybody.
Right. Honorable, my final question to you this afternoon. The Constitution does grant parliaments the authority to create other courts, the district tribunals which were seen also being a part of it. When you raise constitutional challenges, where exactly are they, and will you, should the president assent to this, marshal your forces to challenge this bill when it does become law?
If it has become, now that they have passed it, we will think about it. We'll come out with a statement for Ghanaians to know, and most likely that will go to court on the constitutionality of some of the clauses in the bill.
Yes. You
Did
challenge.
you hear me?
No, I didn't quite catch you.
I said that now that they claim to have passed the law, it is right for us to push so that the president, the president would want to leave a good legacy. Having come first term and this is his second term, I think he should leave a good legacy. We will come out with press statements and whatnot, and we would also write to the president and urge him not to append his signature to this controversial bill. And then I hope he listens. If he doesn't listen, then we would have to file a writ in court and test. And that's what we have to do.
Absolutely. Honorable, I appreciate you for speaking to us this afternoon. I'm sure we will get a bit more in terms of details from you as the days go by in relation to this particular subject matter. We're hoping to get a bit more as well from Inusa Fusheni. He's a former member of parliament. He's a private legal practitioner as well on these aspects in relation to concerns, right? They say that they had wanted ordinary person to be at least a person reaching a tertiary level, that specifics as to a majority arriving at a decision would mean that the ordinary persons could override the chair of the tribunal amongst other things. And so they are hoping the president will not assent to it, but if he should, then we could see possible challenges as well coming forth in the coming days.
Absolutely. Still got a ways to go, and the Trades Union Congress has been chiming in. In fact, the TUC says it stands opposed to the re-establishment of regional tribunals across the country. Now, the Congress argues that bringing back the tribunals would revive painful memories of a chapter in Ghana's history it describes as bitter and unfortunate.
We gonna roll the union on. The TUC is manifestly opposed to the idea of resuscitating tribunals, given our collective bitter experiences with tribunals. The tribunals bill in its current shape and form strengthens our conviction that tribunals must be abandoned. The bill, when passed into law, can be a potent tool for weaponizing justice delivery and entrench the perception held by many that our justice system is up for grabs by the police.
Okay, Abusia, we ne ensema ekoso ewo political highway so chairman Wontumi ne update on ne Supreme Court interpretations no and the Deputy Attorney General why wonders ewo High Court is to say court in the beji atum no ye de ehonsem ebebram ye bedamase samoje penekukuti sa ensemu ye de ma ha gossip politics TV so bedamase.